everybody. Thank you very much for watching. I'm the MD of Flexpo, the event series where we connect job seekers with employers who are championing flexible working. We're very privileged today to be joined by Belinda, the founder of Lionshead Law and an employment law expert, to answer some of the questions that you've been very kind to send through over the last week. Thank you very much to everybody who submitted. Some of the topics that we're going to cover today are things like, can I request to stay on furlough? What options do I have to continue working remotely? Can my employer insist that I return and perhaps on reduced hours or insist on a reduction in salary? Before we begin, I do just need to add that the information and the topics that we're discussing today don't constitute legal advice, and if you do need to instruct a solicitor, you're very welcome to get in touch with Lionshead Law or equally another independent lawyer. So if we kick off straight away with probably the most poised question by everybody, which is, can my employee insist that I return from furlough?
Well, if you've been successfully working from home and you feel that you need to continue working from home, then the government guidelines are that you should be staying at home for as long as you can work from home. And a lot of employees feel, well, obviously I can work from home because that's what I have been doing if they have been working from home. If they're on furlough, then presumably they haven't been working from home. And the employer then, the issue then is, if the employer wants to bring me off furlough, do I have to go into work, or can I be off furlough and work from home? And so there are two issues really. The first is, if you've been working from home, can you continue to work from home? Or is your employer insisting you now go into the office? And secondly, I've been on furlough, my employer wants me to come back, but I can't come back, I've got issues. So should I deal with them separately?
Yes,
I'll
absolutely.
answer the first one. So obviously, if you have been working from home and been successfully working from home, then of course you've got quite a strong argument to your employer that you should be able to continue to do so for the time being. But of course, a lot of people have been working from home because they have to, but it's not been very easy. It's been extraordinarily difficult. They have got children, they've got maybe sick people that they're caring for, they've got 1,000,001 things to do, there's a lot of interruptions, and perhaps the employer feels, well, okay, you've been doing okay working from home, but actually we need the staff back in the office to do the job properly. We've coped, we've managed, we've kept going, but we now need to get things going again properly. And unfortunately, the type of job you do is not something that's sustainable working from home on a long-term basis. So the question then is, what's your reason for not wanting to go back? Is your reason health and safety concerns? Are you worried about going into a place of work that you feel is dangerous? The Health and Safety at Work Act is the relevant legislation, and an employee who believes that they are in serious and imminent danger to either themselves or to others, so including perhaps somebody that they're shielding at home, be able to say, I don't think it's safe for me to come back to work. But of course, the employer has an obligation to make the workplace safe to come back to work, or to take reasonable steps to make it as risk-free as possible. Nothing is 100% risk-free, but to comply with the act. So if the employer has done that and has consulted employees and has said, what are the real concerns? What can we do to mitigate? Can we have screens up? Can we have set washing hand times? Can we have sanitization of keyboards? Can we, and has really done a thorough risk assessment and has come up with a really good plan for getting people back to work, then the question is the employee reasonable? Is they acting reasonably and saying, I can't come back because it's not safe for me to do so? And it's really difficult to say who's right, because every case will be totally fact specific. So there's that issue. The other issue is, okay, but it's not that I don't think it's not safe, it's just that I've got nobody to look after my kids. The nurseries aren't open, the schools aren't open for the kids in my year group. And it's a safeguarding issue for my children. If I'm at work, there's nobody to look after them. I can't take them to my elderly parents. I can't take them to my sister. It's impossible for me to come back to work. In those circumstances, the question then is, should you be stay on furlough, or should you be able to work from home, perhaps on revised terms? I think the key for almost every question you're going to ask me, and I realise I've been talking for ages and we've only done question one.
Well, there's so much to talk about.
There is so much to talk about, but the key really is to talk to your employer and try really hard to come to an accommodation. Try and both be reasonable. You're at risk if you're not reasonable, and your employer is at risk if they're not reasonable.
Yeah, absolutely. Is it one of the topics I think that keeps coming up is this issue around shielding. So I think people are comfortable from their own perspective to say, I'm shielding, it's not safe for me to get on public transport, and I think that's easy for an employer to kind of understand. But the issue of having somebody else in your household that is shielding, is it reasonable to request not to return if your employer has put all of these safety measures in place as far as they can? Is it reasonable to still request to stay at home just because somebody else in your family is on the shielded list?
It is again about what steps the employer has done to mitigate risk. Because yes, if you believe that the person you live with is at risk of serious imminent danger by you returning to work, then that's a legitimate health and safety complaint. And if you're sacked or subject to a detriment for raising that complaint, then you've got a claim. The question is, what's reasonable?
This grey area of being reasonable.
And it's all, with all of these cases, I think the tribunals will look at COVID-19 as a very serious and imminent risk. I don't think there's going to be any doubt that COVID-19 fulfills the criterion of being a very serious and imminent risk to health.
Absolutely.
However, it's whether then the reasonable safety measures that have been put in place by the employer are sufficient to mitigate that risk.
Yeah. Okay. And it's such a challenge for organisations, isn't it? Because you're looking at structurally the facilities that may or may not have previously been available to suddenly, build hand washing stations, etc. I can see why it's such a nightmare for employers. On the subject of children. No, please go ahead.
No, what I was going to say is that, I think I act for, I advise companies, I advise employers as well as employees. I act for both. And the employers that I have been speaking to are doing everything. They're spending every waking moment going through pages and, in fact, volumes of guidance and guidelines and how to do health and safety risk assessments. And, they're doing, I'm not saying that all will be at all, but certainly the people that I've been speaking to are doing everything that they can to try and ensure that their workplaces are safe, and that if they're not able to do that, they are allowing their staff to continue working from home or to stay on furlough. The difficulty with the furlough is that, of course, until August, people on furlough are not going to be able to do any work at all. And now for a business to get up and running again and start being viable again, it needs people to be working.
Absolutely. And that's a challenge for employers, isn't it? So one of the questions that we had was around childcare. So if your children aren't going back, or even, the other kind of challenge also is that some schools are saying, we'll take your children back. Your employer will be saying, well, hang on a minute, you've got year one children, why aren't they going back to school? And that's a very personal decision. There's no right or wrong answer to that. And equally dependent on the school that you go to, the risks you've got in your own family, the information that you've read. What should an employee be doing? There's presumably the employer will be saying things like, well, hang on a minute, what about your husband and his responsibility to childcare? And could you get a nanny? Like, how much can an employer ask of an employee with regards to them requesting to be on furlough because of childcare?
The truth is that a lot of employers up till now have been very happy to put people on furlough. There genuinely hasn't been a need for them to work, and they've been able to get money from the government, and the only cost to them has been, for some of them, they've had to lay out, so they had to pay the salaries before they got the grant. And people are accruing holiday whilst they're on furlough leave, so of course there's that liability. But essentially, it has been fine for most employers to furlough people rather than terminate their employment, and that has been what most employers have done until now. However, employers are seeing that the lockdown is being slowly lifted. and they want to get going. Understandably, their businesses are on the line and they need to start generating income, and that is going to be balanced against the needs of employees, and let's face it, primarily the needs of women, because notwithstanding the fact that it's 2020, most childcare, most everything, quite frankly, falls on women, and they're expected to do all of that and do a full day's work, and men kind of tend to get away scot-free. It's quite interesting. I read an article that scientific research papers submitted by women since lockdown have dropped to virtually nothing.
Really?
There has been no drop in research papers being submitted by men.
That's awful, actually, isn't it?
It's horrendous.
Yeah, and equally, I think, you know, employers should be saying to parents, not women, not fathers, they should be saying to parents and actually to everybody, what caring responsibilities do you have? How can we help with that? Because otherwise, the gender pay gap is only going to widen, because men will return and women
it's going to be enormous. So this leads on to potential indirect sex discrimination. So if an employer says, well, I'm sorry, but everybody's got to come back to work now. We need all hands on deck. You don't have to come into the office. If you feel it's not safe, we're happy for you to work from home, but we're going to be taking people off furlough and you have to be working. There's the issue there is, well, that has an indirectly discriminatory effect against women more than men, because normally it's the women who are juggling the whole shebang at home, and the men are just carrying on having a lovely time at home whilst everything's being done around them. This is not universal, and I don't want to be accused of sexism, but it is statistically correct. Yeah. And so there's this issue of, well, you don't need me to come back. It's potentially discriminatory to require me to come back just because you're bringing everybody else back. Can we explore another option? Can we explore perhaps a temporary variation to my contract? I'm happy to come back perhaps on fewer days, fewer hours, or with some flexibility about those hours. It's not a permanent variation. I don't want to do a formal flexible working request. I understand you want me back, but you need to understand that unfortunately the way it works in my house is that I'm the one who's carrying the can, and it's all well and good for me to say to my husband he needs to carry the can, but he ain't going to do it. And this is what I need. Yeah. The other options are requesting, so there's two other types of statutory leave. There's dependent care leave, which is possibly, it's only useful for very short term. This is an emergency. I need to take time off to care for my dependent. That piece of legislation is not really to enable you to provide the care, it's enable you to put measures in place for somebody else to provide the care. And it's unpaid unless your employer has a policy which agrees to pay for dependent care leave. And then there's parental leave, which is blocks of 4 weeks, which you are entitled to if you've got, for each child that you've got under the age of 18. I can't remember how many weeks it is in total off the top of my head, but it's up to 4 weeks a year. And your employer can agree to more. So you could, per child, 4 weeks a year per child. So you could negotiate, you could try and negotiate a period of extended parental leave. Don't call it unpaid leave or sabbatical, because if it's a sabbatical, your employment ends. These sorts of notions about sabbaticals preserving employment, they don't really. Parental leave does, and you have rights to come back at the end of parental leave. So there is possibly the option of taking some unpaid parental leave. Obviously, that's going to be very difficult for a lot of people because they need the money. But at the end of the day, there is a balancing act between the needs of the employer and the needs of the employee. And going back to what I said at question 1, communicate, talk, try really hard to look like you are trying to come up with a solution that works for them, so that they will hopefully try and come up with a solution that works for you. Absolutely. And do employers have to honour parental leave? They do, but they can't. But they don't have to honour the dates you request. Oh goodness! What an absolute get out! But why wouldn't they? Yeah, absolutely. Realistically, why wouldn't they in this situation? Yeah, because they've got two options, haven't they? They either honour it or they're in a situation where they're going to think we've got to try and get rid of this person, and we could have a lawsuit against us.
Yeah. I mean, it's very difficult for employers, isn't it? Because, you know, if you do have somebody, for example, if you're in retail and you do have somebody that wants to be off for, so they've got 2 children, 8 weeks of unpaid leave, they can't fill that role as a temporary person or bring anybody else in. So I think what you're saying is absolutely right. It's got to be a communication. Everybody needs to see kind of the other person's side, don't they?
They do. And I think employers generally, in my experience, employers really respond well to employees who are trying to accommodate as well. The difficulty arises, I think, when employees go in demanding, this is my right and this is da-da-da, and da-da.
Yeah.
It gets an employer's back. I mean, it's just human nature.
Of course, yeah.
You know, we all know what our rights are, and it's my job to help people to put forward their rights. But very often, going in all guns blazing is not going to get you what it is you are trying to get. Save that up your sleeve if everything goes pear-shaped.
Yeah, no, definitely.
But at the beginning, you know, employers and employees both have exceptional needs at this time. And the more that they can try and accommodate each other, the better. Now, of course, there are going to be situations where you've got a horrendous employer who's just not interested, doesn't care, not worried about the legislation, doesn't care about you. And in that case, your recourse is through the tribunals or the courts, if you want to.
Yeah, which is probably an absolute headache. So, to be avoided if at all possible. One of the kind of leading on from that, if an employer, and this 2 questions in one, if I may, that we've been asked, can an employer request that you return on part-time hours for their own cash flow reasons? And where do you stand if you are actually being paid more to stay on furlough? Can you say that? And is that a valid argument? These are 2 kind of separate questions that we've been asked.
No and no. Sorry, yes and no.
Okay.
So yes, your employer can try and negotiate a contract variation with you.
Yeah, and you can say yes or no to that.
You could say no, but if it's a reasonable request and it has been done with meaningful consultation and the rest of the staff are on board with it and it's been time limited and a very detailed explanation has been given for why it's needed, because if it doesn't happen, then there's going to be redundancies or the business could fold altogether, then you would be a little bit foolish to not agree, because then you could be at risk of redundancy. Having said that, that doesn't mean you should agree to absolutely all and everything. And it is very important when you're agreeing that this is not a permanent variation. What you don't want to find is that you've agreed to a pay cut and reduced days, but that there's no trigger for that to go back.
So should that all be contractually agreed with dates and time frames?
I think so. And very often employers are reluctant to do that. But even if they just say once X, Y, and Z has happened, they might not put a date on it, but they could, I think it would be unreasonable, I think, for an employer to expect employees to accept permanent reductions in pay. Having said that, there may be circumstances in which they say, well, we are asking you to accept these reductions in pay. We cannot say when they are going to be increased, but all we can say is that we have a duty of mutual trust and confidence to you. We are going to be honourable to you. It is not in our interest to have an unhappy workforce, and it is in our interest that as soon as we are able to, we get everybody back to where they were. And I guess it depends on how much you trust your employer, and if you don't really trust your employer, then why are you working for them?
Absolutely.
So again, I think they can't just if they can just impose it, because if they just impose it and you go along with it, you've accepted the variation by conduct.
Okay.
But it would be dangerous for an employer to just do that.
So it should all be in writing in some way.
Well, it should be a consultation first, and get people on board and get them to agree. Any employer who just imposes it, without that runs the risk of people claiming constructive dismissal, breach of contract, unlawful deduction of wages, all sorts of things.
Okay, you as an employee, you should expect a consultation period and then it to be formalised in some, whether there's an end date or not, it should be formalised that the intention is to revert back to usual terms in writing.
Yes.
Okay,
and
that's interesting.
That's for you to negotiate. Now, if this is affecting more than 20 members of staff, then there are collective consultation obligations, because potentially a potential outcome would be redundancies if this couldn't be agreed, in which case collective consultation obligations arise on the part of the employer. So they would consult with union reps or elected representatives. So that's getting a bit complicated. But at the end of the day, what I would say is, I've had huge numbers of people asking questions online about this. My employers asked me to take a pay cut. My employers asked me to work different days. I don't want to. What rights do I have? The answer is, if they were just doing it just because they felt like it and it was capricious, then you just walk out and say, you've effectively sacked me, you've broken the contract. But that's not really what's happening at the moment.
No,
absolutely. Employers aren't doing this for fun.
Yeah.
They're doing this to stay afloat so that they can save jobs.
Yeah, absolutely. That's what it comes down to. And the question around furlough, if somebody is theoretically getting paid more on furlough than they would be if they returned, can they say that? Is that a valid?
They could say it, but as an employer, I'd say, yeah, but you're not making me any money while you're on furlough.
Yeah. So they've got no right to request it.
I need you back so we can keep this business going.
Yeah. Okay. So and then if that kind of came to loggerheads, then it's a case of, you're at risk of redundancy, or you return how we need you to return. If it's not a valid reason for requesting.
The furlough was not meant to be a paid holiday for everybody.
Yeah.
It was meant to enable businesses to retain staff, for people to retain their jobs through an extraordinary time where businesses have been required to close.
Yeah.
And they are now, the economy needs to get started, obviously slowly, obviously with real care and concern for health and safety. But ultimately, I think it would be quite difficult for an employer to cut pay more than 20%.
Yeah.
So I don't think they'd be any probably wouldn't be any less, unless they're told, we're going to cut pay by 20% and we're going to cut your hours and days.
Yeah.
But I think that's quite a lot to ask of people, and I think the whole as a collective, the staff could say, well, then we're not agreeing to that, but we will agree to this.
Yeah, but again, it's that two-way conversation. It
is, but I think the best way to do that is with your colleagues.
Oh, that's interesting. And how would you go about that? So
you would just say, because if your employer is wanting to cut your pay by 20% and your hours by 20%, meaning effectively a much bigger than 20% cut, so yes, you're better off on furlough. Presumably they're not just singling you out for that. Presumably this is going to be something that is done, if not across the whole company, but certainly across certain groups of people in a company, in which case, as a collective, you're going to have stronger negotiating powers to say, well, we understand that you need to do certain things, but we don't think that this is particularly fair, particularly given that those people are not being asked to do this.
Mm-hmm.
And we want to help. We don't want people being made redundant. We want to work with you to save jobs and keep this business afloat, but we don't want to be taking the whole of the can here.
Yeah, absolutely. And then my last question, if I may, because we've kept you far longer than 10 minutes. This issue of wanting to return from furlough. So somebody has put forward a question around some of their team members who are on the same salary, the same position, do the same job effectively, have been brought back from furlough. They found out about this through conversation as opposed to through the business, and they've been left on furlough. Can they request to return? Is there, do they then have a right to say, well, hang on a minute, you brought some of the team back. Should there be a consultation period as to who gets to come back and who doesn't? What does that look like?
Bringing people back from furlough, presumably then they're coming back on 100% of pay, and the person on furlough is still on 80%. I'm guessing that's why they're concerned. The employer will be bringing people back from furlough, presumably on a needs basis, in the way that they furloughed people on a needs basis. They were supposed to do a sort of rough and ready redundancy selection type criteria into deciding who to furlough. Yeah. And it would be a similar sort of process in reverse.
Okay.
Who do we need immediately? What are the skills that we need right now? What are the skills that we can't really utilize now? Who's going to be more, you know, productive? At the end of the day, what that means is that, of course, if you're still on furlough, it probably means that if there are going to be any redundancies down the line, it's probably going to be you, not necessarily, because it may be, first of all, it may be that the employer doesn't want to make anybody redundant. It's just doing a phased return and is doing it on the basis of the needs of the business as it changes, as time goes on. But yes, you can certainly ask on what basis has X, Y, and Z been brought back and I haven't, we do the same job. You can ask that question.
The suspicion of this particular person was around children, so they believe that they've been left on furlough because they've got children. I mean, in a way, that's quite nice of an employer to kind of assume that it might be harder for them, but equally that could also be
discriminatory.
Yeah,
it's discriminatory if that's the reason. Because what the employer should have said in that case is, I'm wanting to bring people back from furlough in this team or this area of work. Would you like to, you know, I'm asking everybody if they are able to come back. I'm asking everybody.
Are
you in a position to come back? The fact that the employer didn't do that, they may well have been thinking they were acting from a place of concern and a good place, but of course the road to hell is paved with good intentions. And you know, there is a risk that this could be direct sex discrimination. If they've brought, for example, men back or women without children back and not this person. The question is, what does this person want to keep their job, or do they want to be negotiating an exit from their job? Because depending on what the answer to that question is, really depends on what sort of advice somebody like me would give them to do.
And actually that's quite complicated, and they would need an independent solicitor potentially.
I mean, at the end of the day, I think it's always you should always take a deep breath before you jump in with allegations or claims, because you need to think what your end game is. What is it you're hoping to achieve?
Of course.
And if you're hoping to keep your job and keep sweet with your employer, that doesn't mean to say they can get away with it, but it will certainly impact how you approach this particular issue.
And that, I'm sorry, forgive me, I did say that was the last question, but somebody's just popped into my head that somebody asked us on Instagram earlier today, which was, can I negotiate an exit from furlough? So if I've decided that actually I don't want to come back, what's the best scenario for them then? Is it still a month's notice? Do they have to give a month's notice? What does that look like?
Well, there's a difference between resigning and negotiating an exit.
Okay, sorry, this is me and my bad use of employment lingo.
So if you're resigning, you just give in your notice.
Okay. So if they were expected, sorry.
So if they're expected back at work,
and
they're saying, actually, I don't want to come back to work, I'd like to resign. And they have to give notice. And the employer in that situation might say, but I need you to work out your notice because I've got to find somebody to cover your role. I can't just leave this role empty. But more likely than not, the employer will agree to waive notice. But if the employer is agreeing to waive notice, the employer doesn't have to pay you for that notice. The employer is agreeing that you don't have to come back and work your notice period. They're not telling you that they don't want you to work your notice period. You're saying, I don't want to work my notice period, in which case the employer can say, fine, you don't have to, bye-bye. But that's it. There's no notice pay.
No, that makes sense. And I suppose the other question that people will be thinking as well is in terms of redundancy. Can you request redundancy? Can you suggest that you would be open to that?
You can. Employer doesn't have to accept.
And I suppose it depends on whether you are hell-bent on leaving or not.
And it also depends on whether your role's redundant.
Yes.
Because if your role's not redundant, you're not redundant, even if you don't want to stay.
Yeah. I suppose you're making assumptions about the business continuity or not.
Well, exactly. I mean, the reality is that, you know, if there's going to be redundancies, then you'll be put at risk. At that point, you could say, I'd like to take voluntary. If I take voluntary and avoid going through the whole process, is there an enhanced package that could be on offer? Have that on a without prejudice basis discussion. But of course, the risk of that is that the employer now knows that you want to go.
Yeah.
And they might not want to offer an enhanced redundancy package, and then they make you redundant and
you're out of a job. Yeah, absolutely. Okay. Oh God, it's so complex. Thank you so much for your time. It's been really interesting for me. I'm sure that there's answered an awful lot of questions for people. So thank you very much.
You're very welcome.
I would just like to reiterate to our audience, I hope you've enjoyed that, that this doesn't constitute legal advice. And if you have a particular topic that you need help with, you need to instruct an independent solicitor, please feel free to contact Lionshead Law to do that. Their website is www.lionsheadlaw.co.uk. That's right, isn't it? Not .com?
It is.
Yes.
Yeah,
so again, thank you so much. You're giving up your time to do this for our employers as well, so we appreciate that. So we'll be doing that next week. You haven't got enough to do currently with what's going on in the workplace. So thank you, and we will thank you to our listeners, and we'll see you soon.
Okay.